thanks for coming. This is a topic I'm actually really excited to talk about. I like talking about religious freedom. And for those that were at the Constitution Day celebration, it's not the same discussion. This is past cases that have gone through the courts, have a resolution at the Supreme Court. And we're going to talk about them and the issues and whether we think they're resolved correctly, incorrectly, and maybe some of the things that we can do, or some of the things that we would recommend to the Supreme Court. Welcome. So we'll see if this does not like to work if I pause it. Let's try this really quick. Sorry. Maybe. There we go. All right. So we try to stay super respectful. We highly encourage disagreeing viewpoints because I'm a firm believer that none of us know all the truth, and we are trying to find it. And so we very much want to promote a founding father style debate, at least as I envision it. I believe that they could passionately disagree, but do it civilly and do it appropriately, and that their ability to have strong discourse produced the Constitution, produced some pretty amazing government. And I think if we go back to that, we could have a lot of progress in our country. So we like to share a little quote about why to be informed. And this one, I went to Isaac Asimov. I love science fiction. And curious what you think Isaac Asimov is saying here. If knowledge can create problems, it is not through ignorance that we can solve them. Any thoughts on what he might be saying?
Think of the Luddites, right? So they were a bunch of weavers who, in response to the new weaving machine, were going to smash all the machines they could. And although they had some right, they thought, this is going to really damage our location. In the long run, it's probably better that they waste all their time doing the same thing over and over again, and that maybe a more expanded way of looking holistically is a better approach rather than trying to bury their heads back in the ground.
Yeah, so knowledge created the problem where it was, we have something new, and now we're going to lose our job, right? And they were approaching the resolution of that through an ignorance type approach. Instead of saying, oh, what do we do about this thing? It's here now. It was, let's just pretend it's not here, get rid of it. And that is something that often happens, is it's easier to just go back to what we know, which was the ignorance before something came. And I look at it a lot with IT. I feel a lot of times our solutions to the IT problems are just to say, oh, let's just make that illegal. And I go, the technology now exists. You can't just make it illegal. Someone's going to use it. We have to figure out now what we do with that. And I think that's how Isaac Asimov thought and approached things. Very science fiction type writer, looked at all kinds of issues. And I believe it's an appropriate way for us to look at it too, to say, things aren't here, what do we do about it? Instead of, let's just make it illegal. And it won't be there anymore. And then to give an overview of what we feel liberty is, we approach it from the perspective that law is necessary to pull us out of anarchy. There's no law, we're in anarchy. The state of tyranny is where it's all law that dictates everything, and liberty is somewhere in the middle. And this implies that morality is necessary, because the only way that you can have a state where there isn't law is if people operate under some collective morality or moral code. And that is where individuals have to come up, have private solutions to things, solve problems on their own. And religion is one of these spaces that requires a fair amount of morality if we want to keep religious freedom. Because when religious people and religions do not follow their own moral code, the laws step in and fill in those gaps, and religious freedom starts to get encroached on. But it's because they're not living up to their morality. So the First Amendment we're talking about today, very first line that at least was voted on by the states to come in. There were some other amendments that didn't make it in with the Bill of Rights. But it's Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So we're looking at the free exercise line today. We're not going to be going through the establishment of religion portion of this today. Except to ask, do you think that prohibiting the free exercise thereof is in reference to religion or establishment of religion? If you were to read that, is it saying they can't prohibit the free exercise of an establishment of religion or religion?
I think that they're talking about actually the establishment of religion.
Okay. And we're going to go into this more because I think actually there's a very fascinating way that cases could have come down if the court approached it from that perspective, where it would have been fairly different outcomes based on if they were looking at this being establishment of religion versus just religion in general. And that's something that okay, that will change quite a bit. So if you are joining us online, you're welcome to pop in at any point if you want. Just kind of jump in and shout something out. And we might have lost this clicker again. That's wild how this works.
I feel like I read that as just being religion, is how I would have interpreted it initially without you having asked that question.
Yeah, because it's specifically saying,
I think more of like the ability to live your religion when I read the free exercise thereof, but.
yeah, and it just says, shall make no law respecting an establishment of religion, which is kind of a phrase in and of itself, a thing.
Mhm.
And then it says, or prohibiting the free exercise thereof. Most of us in today's world have shortened that to be just religion. That's how we've studied it and been taught it. But I think from just a textual standpoint, if you're looking at it, it could be argued that it was talking about the actual establishments as opposed to just anything with religion. But
On its face, I feel like thereof refers to religion. I don't know, because the way religion is placed in the center there, establishment of religion, and then like chiasmus or prohibiting the exercise thereof, religion being the centerpiece between those two ideas. But, it's ambiguous. They could have been more clear.
yeah, there's crazy amount. One of the things about the founding fathers, they weren't great writers. If you've ever read the Second Amendment, it really doesn't make much sense. You just look at it and go, what were they saying? I don't know. And people don't like it when I tell them that, but the Second Amendment really doesn't make much sense. Just from a language standpoint, it's not great. So we come to a case, Brownfield versus Brown. I think this is a fascinating case. So hopefully you guys think it's fascinating too. Pennsylvania has a number of Jews in it, Orthodox Jews. Their Sabbath goes from the sundown on Friday to sundown basically on Saturday. Orthodox Jews, many of them faithfully observe their Sabbath. They close for business. This is still something that's B&H. I went on. It was Black Friday, and I was there to buy something that I needed. They had a great sale on it, and I got to it late that night. And I put it in my cart, and I went to buy it, and it said, "Please come back in 19 hours and 22 minutes." And I went, "What?" It was so unique to me. But then I looked at it, and I thought, "Wow, I actually have high respect for that. Crazy high respect." They even closed the store on their website and went and take orders. And I thought that was awesome. So I had to give them a shout out here. But this makes it so that Sunday is a super important day for Jews in retail because they're closed on Saturday and they don't get their sales, the weekend sales. So Pennsylvania in 1959 says, guess what? We want to close all business on Sunday. Well, not quite all business, but most business. So they actually made it a crime to sell clothing and home furnishings on Sunday. And they wanted it. It says here, you can read why they justified it. But they wanted this day set aside, you know, so we got this group here at the park. Everyone's in the community is just together. We can finally get together and see people because work's off. And we want to make sure that the working person gets a day to regenerate himself. So for these Orthodox Jews, this law comes out and it's killing their business because they're not in business on Saturday and they can't be in business on Sunday. And those are their two biggest days to sell stuff. So just as an aside, as we look at this, because this general welfare comes up in this case. Now, this is what the U.S. Constitution says, but I'm just highlighting the concept. So this is for the federal government. This isn't for Pennsylvania, but it says that Congress has the power to lay in taxes, to pay the debts, and provide for the common defense and general welfare of the United States. And so Pennsylvania, when they're justifying this law to the Supreme Court, they're talking about, well, this is general welfare. This is generally good for most people, and we're pursuing general welfare. So what do you think? General welfare, because the Constitution was setting forth, at least again at the federal level, don't apply this to the state yet, but at the federal level, it's saying Congress can only do the things that we've said in here. And there's this general welfare clause. So can Congress say, it's really good for everyone if they have a day off, we'll make that day Sunday. No business on Sunday. Do you feel that's what the general welfare clause is talking about? Okay.
Almost feels like the original same with respect to the framing, because it opened the door to this whole panorama box of all sorts of things that the government can then do for the general welfare. Literally
And there's a lot of things the government's justified as general welfare. But looking at the whole phrase, do you think there's any indication of what the founders might have meant by general welfare? Or do you think they were just thinking, oh yeah, as long as it's good for the country, it's good for us? I don't know if the founding fathers, with how much they hated the concept of a big, powerful government, would have been okay with anything good for the country is good for us.
Well, I don't think they would have liked this situation, just because when certain states came down and were like, we're gonna be this religion and we're gonna be this religion, they kind of tried to, that didn't go over well. And so I think for them to say, and I know they're saying it's not based on religion why they're doing it, but there's a strong history of a Sabbath day observance on Sunday, which, whether or not you say that, I think it's pretty clear.
Yeah, that's a question. Do you think this was religious favoritism at all? This law they passed?
Yes.
Or I'm just kind of amazed because they convinced the Supreme Court it wasn't religious favoritism. We had a whole secular reason, a whole non-religious reason. They did. Supreme Court said it was okay.
Now, is it in New York? Where is it? They're trying to push store to be open on Sunday.
Yeah, so now it's the opposite issue, right?
Yeah.
So that'll be a fun one to talk about with this. But keep that general welfare in mind, because it goes into, this leads into one of the places that the dissent in this case has some things to say. But just curious, right now, what you know or what you feel, do you think the government should be able to pass a law like Pennsylvania did? say you can't be open on Sunday? You say no.
I say no.
No. No.
No.
Any yeses? Maybe. So it goes into a few of these Orthodox Jews too. And they say this is imposing too heavy burden on us. It's taking away our right to worship as we choose. And one of the things that they told the court is they said, look, all those things it talks about in there, the need to get together, the need to take some rest. They said, we do all that. We have our own Sabbath day. Doesn't need to be on the same day. But the Supreme Court, when they looked at this, they were very quick to say, guess what, Jews? This law is not making you violate your religion, because it's not a sin to not be open on Sunday. And so there is some truth to that. It's not like it was saying you have to work on Saturday. So that's a Chick-fil-A issue a little bit. It was saying you just can't be open on Sunday. And as far as I know, I don't know of a religion that says you have to work for money on Sunday. I haven't heard of one of those, And so they're in arguing about an indirect burden on religion. And saying, because of how my religion is in conjunction with this law, it produces a burden where I have to walk away from my business, give it up. And then the Supreme Court goes into these public welfare laws. And I didn't put the quote in here, but the quote from the case is pretty interesting. The Supreme Court says there's been a huge proliferation of public welfare laws. And they said, as far as we know, those are all valid. And you're going to offend somebody, but because we can do these things, it's okay. And so this is in the 50s. And curious of how you think. So one of the ways to win or lose a case, constitutional cases, and how you frame the issues. Do you think this was an appropriate way for the Supreme Court to frame the issue, to say, it doesn't make you violate your religion? It's not a real problem.
I think it's becoming a religious question, but the religion is just a garb for a financial question. Because I don't know if they would have complained if the Pennsylvania court had said everybody should shut down on Saturdays.
They wouldn't have, but the Christians might have.
I know, but what I'm saying is it's actually then become a proxy for money.
Yep.
I can't make money on Sunday. So how can I complain about it? Oh, let me use religious freedom because that's the rule that we. So money kind of gets pushed on the back. And that's kind of what you described. Like you cannot be forced to work on a Saturday, but you cannot be, cannot claim it as a violation if you don't have to work on Sunday. That won't work. Right then you see it's the money thing raising its head again, pushing through the religious stuff.
Yeah. So there certainly is the money side, but at some point, we have to have money to exist in this world. And so if the government can say, you don't get any money unless you violate your religion, then it becomes this interesting tie. And it goes back to the Citizens United case, campaign finance speech, Supreme Court going, well, can you really talk without money? If you can regulate the money, you can regulate the speech. And with speech, they've come down and said, when you regulate the money, you regulate the speech. With religion, they haven't gone the same way. They let you regulate the money and say, we're not as concerned about your religion, because they're kind of saying what you're saying is, this isn't really your religious issue so far. That's kind of how it's gone. But again, with you, if you have to write for your family, you have a business, and then you have to walk away from it because of some law or your religion, And it's not to say that they can't get a job that works Monday through Friday. Maybe they can, maybe they can't. But they lose their whole investment in their business. But again, that's a money thing, right? But in framing this is one of the ways that a dissenting justice framed it. He said, Pennsylvania has passed a law which compels an Orthodox Jew to choose between his religious faith and his economic survival. So he agrees there's money in it. He says that is a cruel choice. It is a choice which I think no state can constitutionally demand. For me, this is not something that can be swept under the rug and forgotten in the interest of enforced Sunday togetherness. So he frames it a little different. He says, you're making them choose one or the other. That's a cruel choice. Another justice that dissented, and I really like the way he framed his. I think it's pretty interesting to look at here. This justice says the court has demonstrated the public need for a weekly surcease from worldly labor and set forth the considerations of convenience which have led the Commonwealth of Pennsylvania to fix Sunday as the time for that respite or respite. I would approach this case differently, he says, from the point of view of the individuals whose liberty is conceitedly curtailed by these enactments. For the values of the First Amendment as embodied in the 14th look primarily towards the preservation of personal liberty rather than towards the fulfillment of collective goals. So he says what the amendment is about is making sure that the primary purpose is to preserve personal liberty. And he says that public welfare laws, if your basis is public welfare, it's not as compelling a reason to regulate. And that it should give way to the rights set forth in the First Amendment. Curious if you have any thoughts on that with this dissenting justice and his response. Agree, disagree?
I think he's right on that point. Yeah.
Okay, so you agree with him?
Yeah, I tend to agree with that. I think it's more, it supports the limited government. Government involvement, but
Yeah, he's trying to breathe some life into the First Amendment to say this was here actually put in to protect against government encroachment on personal liberty. That was the basis for the Bill of Rights. And so even if the government has a valid public welfare reason, which he says, yep, Pennsylvania puts it forth. They say all the reasons why it's a valid reason. Said, but that doesn't justify taking away personal liberties that are guaranteed by the First Amendment. And so this is a case that this dissenting justice cited. And he goes, look, if you've forgotten, the Supreme Court says you just said this a few years ago. And so what the Supreme Court said a few years before this case was the right of a state to regulate, for example, a public utility may well include, so far as the due process test is concerned, power to impose all of the restrictions which a legislature may have a rational basis for adopting. I put that in bold. As rational basis just means you give any explanation as long as you can explain why the court's not going to touch it. So if they come out and say, yep, we're charging people based on connection to the grid, or we're charging people based on usage of kilowatt hours, or however they choose to charge, the court's not going to come in and say you have a constitutional right to be charged a certain way. The legislature had a rational basis to do what they did, and they're not touching it. But the Supreme Court said that freedoms of speech and of press, of assembly, and of worship may not be infringed on such slender grounds. They are susceptible of restriction only to prevent grave and immediate danger to interests which the state may lawfully protect. So what he's articulating here is this grave and immediate danger over time has come out to be what they call a compelling interest. The government has to have a very compelling reason to take away these personal liberties. And the court has really moved that way with things like speech, where if they want to restrict speech, they have to have a very strong, compelling moral basis to do it. And so the court will, when they get a constitutional challenge, they'll look at it and say, does this violate the Constitution? So if the law says you can only use so much money in a campaign, they'll say, yep, that violates the Constitution, it restricts your speech. But is there a compelling interest to do so? And in the campaign finance context we looked at, the court said, Yeah, preventing corruption is a compelling interest. There's this moral basis for it.
I'm curious, the difference between rational basis and grave and immediate danger, it seems sort of like emotive. Like, it's not clear to me that I could just pick out like what is grave and what is rational and just sort them that way. It seems like it runs into the problem of my grave and immediate danger might be somebody else's rational basis. They seem quite quickly interchangeable if you're not careful. How did they sort, how are they theoretically supposed to sort between those kind of problems?
Yeah, it's a great question. And they don't expressly say, I don't know of any case that expressly says, and it's one reason that constitutional law kind of goes all over the place. Because in the Constitution says the Constitution is the supreme law of the land. But when justices look at it, they say, well, is there a good reason to go against this? If there's a good reason, then they allow the government to continue doing what it's doing, even if the Constitution says no. That good reason, though, my personal belief is the justices are always looking at an underlying morality. And they're always appealing to the sense of societal morals to say what is appropriate, what isn't. And we looked at one case before with speech where socialists were saying, hey, the 13th Amendment, which bans slavery and involuntary servitude, means that the government can't institute the draft in World War I. And they were making that case. These guys were arrested for publishing pamphlets that said, fight the draft. And they were put in jail. They appealed it. The Supreme Court said, this is really dangerous to the country if we can't draft people, so put them in jail. Nowadays, that case is viewed as wrong. The morals of society have changed. And that's one that they look back at and say, yeah, that wasn't really a justifiable basis for restricting speech then. But to your point, it very much appeals to the morals, the political climate, a lot of what's going on in the day to say what's grave and immediate danger. And that's
I might think like, I'm Pennsylvania and I see people being worked to death. There's a grave and immediate need for rest. And it just so happens that people must have Sunday off. This is my excuse, whatever. Maybe not an excuse, but sincere belief that these people need rest. And this is the most rational utilitarian choice.
Yep.
It just seems tough to.
And the justice, this dissenting justice actually addressed that. He said, even if they were to argue that it's so necessary to make people rest one day a week, he said the Jews are resting one day a week. Right. And he said, so Pennsylvania's thing then is really coming down to, do we have the right to force people to do it on the same day? And when it came to on the same day, is there a grave and immediate danger? Pennsylvania could say, well, families can't see each other, extended families, if they're not off on the same day. But that, they didn't have evidence to say there was something really bad going to happen if extended families had to go for a year without seeing each other. And so part of it is the courts will look to evidence to see what is the studies say, the statistics say. So these things all come into constitutional cases in determining it. There's one I was talking about today with some attorneys from DC. There's a constitutional case where they were trying to decide if the EPA had the authority to regulate water bodies that were entirely contained within a state. Because the federal government's basis for regulating environmental stuff is interstate commerce. So they're saying when things move between states, we need to regulate it. And so this one body of water, small pond or something, they were restricting development. They'd sued trying to say the EPA doesn't have jurisdiction here. And the attorneys in the case for the government were pretty ingenious. And they went and got some evidence of migratory birds that flew from one state to another and landed in this little pond on their way there. And they put that into evidence. And they found something to say there was some interstate occurrence going on, put it into evidence, and it made it all the way to the Supreme Court. And they said, yeah, those migratory birds give the federal government jurisdiction over that little pond that doesn't go anywhere. Now, I don't necessarily agree with the outcome, but I do think those attorneys were very ingenious to put that in. But it is to say that constitutional challenges will look to what's happening in society. They always do. I've never seen a constitutional challenge that's insulated from looking at the morals, the just talking points, all those things. All that influences how they interpret these things. But the rational basis is, the courts do say with rational basis, even if we disagree, that's a valid reason, as long as there's somebody somewhere that can articulate why it was chosen. You know, we chose to drive on the right side of the road. Why not the left, like most of the rest of the world? Well, you know, or we chose miles instead of kilometers. Why? They had a rational basis, the court's not going to touch it. And it's a very low standard in court. The compelling interest standard of this immediate and grave danger, they have required a lot more. They require an actual showing of some type of harm they're trying to protect against. Whereas rational basis doesn't even have to show harm. It can just show benefit. The Supreme Court also looked at the claim from the Jews that this law was favoring some religions, but not others. And so a type of religious discrimination claim, essentially. And the Supreme Court was pretty dismissive and just said, you know what? We have so many religions in this country. There's no way to pass a public welfare law without making someone mad. I think there's some truth to that. But from the context of the First Amendment, free exercise thereof, what is the First Amendment protecting? When we have a highly diverse religious society, people of all different religions and walks of life.
Prohibiting the free exercise, potentially.
Yeah, so what does that protect? That right's in the First Amendment. But the Supreme Court's saying there's so many religions, there's public welfare laws.
Well, if the public welfare, for general welfare law is making it so that you have to choose between your religion or keeping your family afloat, then that makes it pretty hard. It's kind of like prohibiting your exercise of your religion.
And that's what the Jews were arguing, but the Supreme Court didn't agree with them.
Okay.
So the question I'm asking is, if it doesn't protect that, then what does it protect? Do you have any ideas of what it might protect still?
The right's the best one.
The rights of the best man.
Well, it still would seem to not force you into proclamations of belief or your own, in your heart, what you believe. You can continue to practice it will be ruinous in this case, but it is not coming to your door and making sure you're a Christian or whatever. So I'd say their premise at least is that's the difference there.
Yeah, so that is the premise.
Thing, but not what you do.
And the court says that. They said, the law can't tell you what to think or believe, but it can tell you what to do. Was essentially how they came out in this case. But my question is, can you truly believe something if you can't act? Is belief purely something that only exists in the heart? Or does it spill over into actions?
If it can't spill over into action and how you actually live your life, then it's not. It's not a. Yeah, it isn't.
And one of the things I look at, if you go back to the First Amendment, it says the free exercise thereof. What does exercise mean? Is that just what's in my heart? I think it's pretty clear that it was protecting actions. To say free exercise of religion. Religion is the basis of beliefs. That's what religion is. And they said you can't prohibit the free exercise thereof. And the Supreme Court says we can regulate actions all we want. And they don't quite say all we want, but we can regulate actions quite a bit.
Well, to some extent, they have to be right?
And that we live in a civil society.
No, they do, and we're gonna get into that. There is, to some extent, they're correct.
Yeah.
Because there are many examples we can point to in religion that we would not tolerate in society. And the Supreme Court brings this up in we'll get to this case, but the polygamy case. They say if people believe in child sacrifice, can we not prevent that? And so to some extent they're right. But then this is where we get even on this balance scale. We need something to pull us out of anarchy. But what's the morality that's supposed to stay to stop us from having the law tell us anything? And what's this principle we're looking for to say, what actions can they regulate? What actions can't they regulate? Did you have something?
I was just thinking that the irony of this whole situation. They're not saying they're creating it for a Christian society, but they basically are. And the Christians believe that Sabbath day, Sunday is a Sabbath day, and it's a holy day to them. But the Jews apparently make a lot of money on Sunday. From
Yep.
Christians who aren't supposed to be buying.
Right.
But it's really ironic how this whole thing is playing out.
Yeah, and there's so many of them going to buy stuff that Pennsylvania has to say, whoa, we gotta shut this down because you're not following your own religion, guys. So Pennsylvania's stepping in to help the Christians follow their own religion. It is ironic.
Did you say it was for clothing and furniture?
Yep,
That worldly stuff?
that worldly stuff.
The Sabbath.
You couldn't stop them from selling groceries, those are necessities.
Yeah, they had some things like that. The necessities could still sell. But not that. But we do have this highly diverse society. So one of the ways to try and break it down here a little bit is to say there's at least 3 levels. Might be able to create more, probably can create more. But religions will have concerns over something like the level 1, which is the person's morally opposed or religiously opposed to what the law is doing. But they don't have to be involved at all, other than maybe the payment of taxes, which goes into a general fund. So there are people that say it violates my religious beliefs if the government funds abortion. Or if the government funds a war. I'm morally opposed, religiously opposed to war. I shouldn't have to pay taxes. That one, I personally don't feel that level is violated. I don't feel that violates the free exercise thereof. If the government does something that a religion is opposed to for some reason. But I'm curious if any of you have different views on that. Or if you feel that level 1 would not violate the First Amendment.
It would depend upon how directly you would be contributing to that act. I mean, if you're being taxed and 75% of the tax that they're taking from you is going to pay for something which is directly against your religious beliefs.
Like a war.
Yeah, or anything, then that would, and then they are making you work for something which you are morally opposed to. But if it's a drop in the bucket, then that might not be. If it's an insignificant amount, then I think that argument might hold. But it would be difficult in practice to really be able to actually say where the money was going. Because we could always.
But the government just say, oh, your tax funds actually went to pay for the roads. You're good. We didn't use your money for that. We allocated all the roads. Your religion uses roads, right? All right, we're good to go. And it is an interesting point to make with how much incredible amounts of money our government spends and on so many different things. I think it'd be hard to have anything more than a drop in the bucket, even with defense spending. It's still percent-wise, I don't think it reaches 50%. I don't think it's anywhere close to 50% of the budget. So that would be interesting to look at.
It is interesting because like we probably advocate some of our moral responsibility for this priority and say, you know, it's the government, they're gonna do what they want with their money. If the city takes some ownership over their actions and say, hey, like I'm genuinely opposed to you using my money for this, then you can use your voice for good morally. Like I'm thinking of Henry David Thoreau going to jail over slavery and the supporting of, I think it was the Fugitive Slave Act. He didn't want his taxes to go to help support that. But he went to jail over that. And that's like a courageous moral act. So I
Yeah.
think if you really care about something, putting your foot down and say, I don't want to support this is probably worthwhile. But it's also, like you say, there's a distance between anarchy and like a totalitarian government. And it would be very easy to get into anarchy if we just let everybody get by with whatever excuse they want if we're not paying taxes.
Yeah. Matt?
Yeah, and just to go with that, I think that's exactly what everybody should do. I just don't know if you can use the argument of religion for it. I think even a religion has a right to say, we don't support this, try to rally its people to do exactly what you're saying. But I don't know if there's to use the First Amendment to say you're violating that.
Yeah, California. So I'm licensed in California and I have to pay, I'm conscripted into a union as an attorney. I have to pay my dues every year to stay an attorney. And California's, they actually let me opt out of a portion of the dues if I'm opposed to what they're doing with the funds. So they have these different things and they say I can deduct, $2 for my bar dues if I'm opposed to it. And I deduct it. I take it out. I'm not paying that $2 for that. And so maybe taxes can be the same. We just get a laundry list of all the things like, oh, opt out of that, opt out of that. And maybe we put a thing on that says you can't opt out of more than 1% of something you're morally opposed to. I don't know. It'd be interesting. And you don't pay towards that
That'd
fund.
be a good democratic experience in terms of us engaging with the way the government spends money.
Yeah.
Might be a good idea.
And an interesting check and balance, right? To say, no, we're not going to fund that government. And then the government says, oh, no one funded it. They all opted out.
Except everyone would just not fund the IRS and
That's a great point.
It's interesting though. I was on student government at UVU, and it was very eye-opening to see where student fees went. And there definitely were a lot of people who'd come in and be like, why is my student fees going towards the mother's lounge? Like, I'm a single student, like, or why is it going to athletics, And those weren't religious questions, but it was just kind of like, it's the price you pay to go to the university, and you can still come and make your voice heard and try to support different things. But like, this is a whole university and it's a whole thing because there's all these pieces. And if you just got to pick and choose your thing, like this wouldn't be a university. Like
Yeah.
it wouldn't have any structure to it.
Yeah.
And so,
And that's the piece of the government saying we have to pull the country out of anarchy somewhere. Because if everyone just gets to pick and choose, it's going to fall apart. So there has to be some level of protection. But the second one is kind of where these Orthodox Jews were at. There's a conflict created in your life. You have to make a choice now. But it's not requiring you to break your religion yet. And then the third level is the law actually criminalizes you doing something that you believe you're required to do. And curious if you think, again, with number 3, we talked a little bit about balance. We're not going to allow child sacrifice. And this is, I was actually fascinated by this. My son that's 11, he asked me what we're talking about today, and I said religious freedom. And he goes, oh, he says, yeah, that's interesting. He goes, what cases are you talking about? He goes, you're going to talk about polygamy? And I said, yeah, we have a polygamy case in here today. And he goes, yeah, he goes, yeah, because those Aztecs would have a hard time in our country because they couldn't practice their religion with child sacrifice. I went, how does that work? Where do you get those thoughts from? I don't know. But he knew the Aztecs wouldn't do well here in America. So there was a piece of it that he's going, yeah, You can stop child sacrifice. And it's not going to be something, even though the Constitution says on its face, can't prohibit the free exercise thereof. The courts are going to look and say, morally, we can. We're going to do this.
Which that one I think is the closest to showing it looks at what's morally acceptable.
Yep. And they are. They're going this grave and immediate danger, this morally acceptable thing of, no, we don't like this. So we get into polygamy now with Reynolds. George Reynolds was a member of the Church of Jesus Christ of Latter-day Saints back in the 1800s, late 1800s. And at the time, he at least said in court, this was his statement, that in order to be in good standing, he had to engage in polygamy since he was commanded to. And that if he didn't, he could lose his good standing in the church. And he said he would not be able to make it to heaven based on his understanding of the beliefs. That's what he put in the court record. He was prosecuted and sent to jail because polygamy was illegal. And so he appealed and he said, hey, you can't criminalize my religion. And curious what you think of this. Can the law criminalize polygamy and not violate the First Amendment? So what do you think the answer should be to that?
It has to violate the First Amendment if it does that.
So you think it violates the First Amendment, saying absolutely violates the First Amendment. Why do you think that?
Marriage is sort of by definition a religious act. So if you're prohibiting or if you're restricting or if you're getting involved in it in any way, you're basically putting your fingers in the middle of a religious situation. That kind of also leads to the question of to what degree should the government be handing out matrimonial certificates and all this other stuff as well.
Yeah. Thanks for those thoughts. Anyone have any other opinions?
Well, and you don't have to go over this right now, but I'm curious, what does someone do who is from Iran or Iraq, who does have multiple wives, can they reside in America with multiple wives?
Yeah, so currently in America, again, this is this moral quandary. Polygamy is still legal in many states, but they've stopped enforcing it. Because what happens is you put a dad in jail and you leave 30 kids that don't have a provider now. And it creates a burden on society and the government. And so for the most part, we still have these laws in the book that say it's illegal, but it's not being enforced.
There's moral outrage until it hits their pocketbook.
Yeah. Going back to Gopi saying money controls everything. Yeah, that's not quite what he said, but talking about money is the basis for this decision, right?
Also, wondering if it is a constitutional standard that we need to be thinking about, the movement that we need to be thinking about, right? Wherever the standard is, which direction it is going.
Yep.
Is it going in the direction of making it so that people free actions are more and more frequent for whatever reason or not? So when you say when people, what will in today's society will be seen as a horrible crime of sacrifice of any kind in humans. That was the norm probably thousands of years ago, and it's probably even is in small pockets in tribal regions and so on and so forth. So there you're looking at one standard. Then there is a standard where you don't do that. Then you violate the other person's right less and less and less. And then you open up the freedom more and more and more. So it's just the direction. I mean, we can be very good in the standard, but we can be headed completely wrong.
Yep.
So, more the direction, I think, rather than what we're heading on.
And one big fight in constitutional interpretation is whether there's a living constitution or a fixed constitution. And those that argue for the fixed constitution say it's fixed in the morality of the time it was set in. That's how we judge the basis for everything. The more living constitutionalists say, no, it adapts to the morals of the day. So cruel and unusual punishment, they keep, in the beginning of America, you could put someone to death for all kinds of things. Tons of offenses were punishable by death. Now, virtually nothing's punishable by death except for premeditated murder.
I'd be shocked at like a 30-year sentence that would never have happened to anyone essentially, like a 30-year sentence.
Or a life sentence.
Yeah,
Yeah.
that would have no been cruel or unusual for that. The idea of something somebody did written that wrong.
And
But like, it's not that morality only goes towards a more just world. It's that it's just different than it was. then.
Correct. And I think that's one of the things that Gopi's mentioning is we're moving. There's nothing to claim it's necessarily more just because our morals have changed. They could have had some very good morality then that we don't have now, but we could have some better morality now than we had then. But what is the purpose of the Constitution? And how do we interpret these things? Is one of the underlying questions and major debates that still rages. People don't agree on, and they get so upset at revisionist judges that impose new things, but ultimately what the judges are doing is looking to what they feel is the moral basis of the day. Even look at a case like Roe v. Wade, came out, tons of conflict, eventually gets overturned. There's this underlying look to where society's at. I personally believe very strongly that we as a people have far more control over how the Constitution is interpreted than we ever give ourselves credit for. I think there's an incredible amount of control we have over the things we say, the things we do, the things that we talk about as being bad or good. Because even when the Supreme Court goes through this Reynolds case, they went very lengthy, took a ton of room in the case to talk about the moral justification for regulating marriage from a civil perspective. The Supreme Court went to great lengths to say this has been a long-standing government tradition. This is something we've been involved in forever. We've been keeping marriages to two people for a long, long time. And they went at great lengths to articulate all that, to say we have a very compelling reason to be in this because our history and tradition demand it. But interestingly, they also did something else where they went and said, what is the religious freedom protected by the Constitution? What does that even mean? And this goes to where we get to the point of looking at religion as an individual matter or as an establishment matter. I really think if the Supreme Court had delved into the establishment side of this, we could have a very different potential outcome. And I personally think it may strike the balance a little bit better than the personal side has come down to. But the Supreme Court took religion to be a personal thing, meaning you could be the only person in the world that believes that, and they're saying you're protected in those beliefs. But that creates a standard that is very anarchy in nature when applied to a whole group. But they look at this. So 1784, a few years prior to the Constitution, Virginia introduced a bill establishing provision for teachers of the Christian religion. So we're going to help you out, guys. Virginia liked the Christian religion, I guess, at least this one bill author did. And there was actually a lot of opposition to it. James Madison, Thomas Jefferson were both opposed to it and said, whoa, you can't be giving stuff to teachers of religion, favoring a religion. And so Thomas Jefferson, in response, introduces the Religious Freedom Bill. And the court goes to this to look at what they feel religious freedom means. Again, this is pre-Constitution. But James Madison says that religion or the duty we owe the Creator was not within the cognizance of civil government. So Madison's taking this approach to say religion isn't something that the government can even touch. Which is leading the court to say, oh, he's just talking about beliefs. Government can't touch beliefs, but it can touch action. So religion must not mean action. And then Jefferson goes on to say that to suffer the civil magistrate to intrude his powers into the field of opinion or belief, and to restrain the profession of principles on supposition of their ill tendency, is a dangerous fallacy which at once destroys all religious liberty. So he says you can say what you want to say, you can believe what you want to believe, but he says that it is time enough for the rightful purposes of civil government for its officers to interfere when principles break out into overt acts against peace and good order. So Jefferson in his bill said, you can believe, you can say, but when you act and you break peace and good order, the civil government can step in. And that's not, your religion stops there. Curious, do you agree with him? Disagree with him? What do you think about that?
I think it's interesting just from a logical standpoint that James Madison's basically thinking that we can't stick our fingers into religion. We can't do anything about religion. But in order to be able to do that, he has to define what religion is, which is almost, yeah, that's a very fundamental way of getting involved in religion by defining what it is in the first place.
Yeah, there's a lot of power in definitions, right?
Kind of the screaming ambiguity of a peace and good order, like what that means. Like again, it just sort of the interpretation comes down to whoever's doing the interpreting can decide what peace and good order means.
Good order to me sounds a lot like tyranny. Oh, we need good order. We're just going to tell you everything to do, right? I think it could be taken to that extreme.
It's just like you can't leave your crap in the road or whatever.
Yeah.
They couldn't mean anything.
Yeah. And so the Supreme Court says in these two sentences is found the true distinction between what properly belongs to the church and what to the state, which is the church can talk in your heart and you believe, but the state can regulate action. And they're drawing a pretty hard line.
I mean, going back to the definition of religion, the farther back you go in history, the more and more religion is a ritual act and less something that you believe or think, something that you full on only do. So they're very, very much getting in the middle of what religion is or isn't.
And one of the things the court conveniently leaves out in all these cases is the meaning of the word exercise. They just kind of gloss over that because it forces them to talk in a different way. But if we look at this from the perspective of what if religion is talking about an actual establishment of religion, and it's not just what an individual believes, but if there's a group of people and they've actually created a religion and it's an establishment, you don't have as much of an anarchy type thing of just, well, I believe this and I believe that and protect this. If you read the cases, the court challenges that come up on free exercise of religion, they're crazy. It's literally wild what people will say. There's one guy that sued that said, my religion requires that kids in school say this certain pledge of allegiance, and it's got the F word in it, all kinds of things. And he was suing to force the public schools to use his pledge of allegiance so it didn't violate his religion. And the courts deal with these things all the time. And I think that because of what people were pushing, where they wanted to say, I want an exemption here, or you've got to do it my way, or all these things, the courts just kind of over time just pulled back more and more and God, yeah, we can't give all these people exemptions on all this personal basis to the point of taxes. But if you had a religion that said, yeah, we're actually crazy opposed to X, and members of that religion who were in good standing could say, yeah, we don't want to pay it. It's not as much of an anarchy situation as just any individual opting out and you have no idea what they really believe or not. They just say, oh yeah, that's my belief today. It's a little different if you have to actually have to live the religion to get the exemption. I'm not saying it's right still necessarily, but I think it is a little bit different. So this is Thomas Jefferson. This is actually the famous quote that gives us this notion of separation of church and state. So again, Jefferson is one that led to a lot of the court's interpretation of free exercise of religion and the other, so of religion in general. So he says, believing with you that religion is a matter which lies solely between man and his God. He says, so he doesn't account to anyone else. He says, the legislative powers of the government reach actions only and not opinions. So Jefferson was really big into this. He says, I contemplate with sovereign reverence that the act of the whole American people, which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. That's where we get that notion from. Adhering to this expression of the supreme will of the nation in behalf of the rights of conscience, I shall see with sincere satisfaction the progress of those sentiments which tend to restore man to all his natural rights. Convinced, so Thomas Jefferson is convinced that you have no natural right in opposition to your social duties, meaning no personal individual right can exceed or can let you opt out of your social duty. Jefferson's quite the guy.
That's pretty collective.
Jefferson was, I don't know if this was divine or not, but he was in France when the Constitution was created. He wasn't a part of it. But we look to him, the courts looked to him as being one of the main interpreters of the Constitution, even though he wasn't even there. But what do you think about that? Do you have no natural right in opposition to your social duties?
That's a really dangerous.
That's really dangerous.
Yeah. And it's also, I had never really noticed it before, but the very idea of that legislative powers of the government reach actions only and not opinions. It's terrible, no, but it's an extremely religious point of view. So it's highly Protestant Christian and is even anti-Catholic in its disposition. So it is very much a religious disposition, which is forming this particular political idea.
The good luck spot thing.
Yeah, I mean, the idea that religion is solely faith and has nothing to do
With action.
or acts. Yeah,
Yeah, so you're saying the Protestant view is, I just said, I accept Jesus and I'm saved, no actions.
yeah. So this particular view of the relationship between religion and the state works for a particular
Religion. Gotcha. Yep.
I'll defend him a bit in terms of social duties. He's an enlightened thinker, right? So that can be a quite encompassing idea. And social duties can include a lot of things. It can encompass a level of morality, careful thought that you wouldn't see as in opposition to the other things you believe, right? You believe there's a system to all things. They fit together. There is a logic that underlies the world, right? So social duties are a thing that exists out there like rights, right? That they actually are a thing that everyone should subscribe to, believe and have.
Yeah, and to that point, if we look at trying to understand what he was thinking, if his opinion is that these are your social duties, then he's saying that this is what's absolutely necessary to pull you out of anarchy. You have to have certain duties that exist at a societal level in order for society to exist. And individuals can't just come in and say, not me. Everyone has to follow these. The question is, how far does he feel those social duties go? I don't know. I haven't read enough Jefferson to know, but to your point, he's an enlightened thinker. The courts, though, are kind of taking it to say, any action anywhere on this spectrum. And the courts, I don't think, are giving credence to the fact that, yeah, Jefferson could have been talking about the need to pull us out of anarchy. He's also he's been on the tyranny side and said, no, we don't like what the king's doing, just declaring all law. But he does say, they give nod to the fact that there are social duties that exist. There are certain things that everyone has to do if we're going to have a society. I think the reason that we get very concerned about it is because, from a language perspective, where does that begin or end with social duties? I don't know. But from this balance perspective, to pull out of anarchy, you do have to have something that everyone just has to follow. If you have personal exemptions for this side of things, it starts to get very difficult for society to stay together.
So is this social duty, like, are we talking taxes, are we talking?
Taxes would be one. I'm actually pretty sure Jefferson would say yes to taxes.
Yeah, I'm assuming he's basically indicating anything that's become law. And he's trusting to
Following the law.
he's trusting to the system of governance and assure that the laws themselves don't become tyrannical.
And that was part of the system, was checks and balances. They did believe that it was going to produce a just thing. One of the fun things to point out about Jefferson is as soon as he gets in to be president, he starts putting people in jail for talking out against him. So Jefferson, apparently part of the social duty is not to criticize Jefferson. So under the Alien and Sedition Acts, he threw people in jail for criticizing him. He was a kind of a firecracker.
He was also anti-federalist, that he bought the Louisiana Purchase
Yeah.
with federal money that he didn't have. So, he's a weird guy.
he was a little bit all over the place.
Now, even in his quotation that you pulled out last, there is a logical issue, because if you say the social duty, it implies following of law, his whole quotation is about what should be the criteria for the law. So it's kind of circular logic. These are what are the criteria that we need to make the law, and one of the criteria is you should already follow the law.
I think the reality behind what he's saying, if we were to use our modern language, we have no natural rights in opposition to the national interest.
I don't think that's what he's saying.
I think that that's become what he's
That's
saying.
it, that we have to
Well,
do.
but duties, it has a particular valence that is not national. Duty is a thing that you owe others, not that is imposed upon you. So I think he, at least from my perspective of him, he's less totalitarian than all of that.
Yeah, so you're thinking he had something in mind that was limited on the duty side.
Well, obviously, he was a founding father. He understood.
He didn't want tyranny.
Yes.
He was opposed to that,
Well, and I think that's the
tyranny unless he was.
unless he was the parent.
Well, I think, yeah, that's kind of, I mean, he's feeling pretty good about himself. He just helped create this new country. And so anything outside of that would be outside of the social norm. But, and I'm not suggesting that he would, but it's like, as long as you feel good about the social norm, it seems pretty logical to say you shouldn't step out,
Yeah,
you know?
we're all very comfortable with that, right? Oh, I believe that. Yeah, you shouldn't
Yeah,
go against that.
And so it's like, would he then apply it and say that social norm, then no matter where it is, would he then stand behind that and say, I'm gonna let the social norm judge, or is it from a context of, no, like, we've got a pretty good thing here, and if you wanna go one off with your little religious belief that's not here, that doesn't fall into this. And I'm not saying that's what he is saying, that's more of a question, like, would he have then imposed it in the future and say, no matter where the social norm goes, we're gonna follow that?
Yeah. I think it's a good question. And I don't know, I haven't read enough Jefferson to fully know the answer to these things. But what I'm pointing out is how the Supreme Court's using these quotes. And the Supreme Court, they may be cherry picking Jefferson. He may have had stuff on the whole tyranny side of the balance that said, whoa, you can't do this, you can't go here. Here's the delineation of social norms or social duties, these things he's talking about. But the Supreme Court didn't put that in. And they go to Thomas Jefferson and say, Jefferson's the one to tell us what religion is and what's meant here. And so this is the Supreme Court, coming as this does from an acknowledged leader of the advocates of the measure. It may be accepted almost as an authoritative declaration of the scope and effect of the amendment thus secured, even though Jefferson was not here for it. Congress was deprived of all legislative power over mere opinion, but was left free to reach actions which were in violation of social duties or subversive of good order. So the Supreme Court takes this quote and just sticks it in there, and he's like, Jefferson's the man. Who can argue with Jefferson? And that's how they interpret religion. So from the beginning, so this is again, polygamy back in the 1800s, they come down and say, religion, that's just belief, not action. And that sets up some very interesting trends as these things go forward. And so this is an interesting one because the Supreme Court goes to the anarchy side that we talk about. If religion's personal, which the Supreme Court's adopting, the religion's a personal thing. They say, so here, as a law of the organization of society, under the exclusive dominion of the United States, it is provided that plural marriages shall not be allowed. So this law of the organization of society, he's talking about marriage. This is after their long explanation of marriage and the history of marriage and all those things. He says, can a man excuse his practices to the contrary because of his religious belief? So can you say, yeah, law, you can't touch me because I have a religious belief? And then they say to permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. So anarchy. Government could exist only in name under such circumstances. Yeah. I want to ask you though about this line. To permit this, so to allow this man to have multiple wives and not go to jail, would be to make the professed doctrines of religious belief superior to the law of the land. What is the First Amendment's purpose? Isn't that its purpose? At least I'm really trying to understand this because I'm going, wait, the Supreme Court just said the government actually can't pass a law that takes away my free exercise. And the Supreme Court's saying, if that were the case, your religious belief would trump the law of the land. That's not what it meant. And I'm going, I really thought that's what it meant. Maybe I'm really not smart, but I really thought that's what the amendment was for, was the law can't do this to you. And your personal rights in this situation do trump the laws of the land. So curious, and this is what I'm looking for help on. What is the court talking about? What is it saying here? Do any of you have any ideas or anything that could say? I can understand their point about anarchy. If every individual could just say, I believe X, and therefore don't prosecute me. If they come after you and say, you killed him. God told me to, so you can't do anything about it. I get that.
They're running away with give unto Caesar what is Caesar's.
Okay. So they're taking that Bible principle and extending it real far.
Yeah.
But it begs the question all the way back in the late 1800s, well, what is the First Amendment? What is it if my belief can never trump the law of the land, then what's the First Amendment talking about?
I would say that marriage is a societal norm that they can use to override that First Amendment. And that's how I see it. I think they're just trying to explain why it's justified in this case.
Okay, so you think it's just the case specific that they're talking about?
Well, yeah, because I mean, there's a long history. The reason there's a long history of marriage is because we're trying to establish that societal is more and more for all of our good. Have marriage be between man and woman. Therefore, we can settle in there and do.
They
Okay.
see it as necessary for a good social order.
Yeah, and they were very strong in articulating all the reasons why that was necessary for society. But I still get concerned about this. To permit this would be to make the professed doctrines of religious belief superior to the law of the land. And I just think,
It's a really dangerous statement.
yeah, to me, it's pretty strong to say the First Amendment's not doing too much here.
But now there's recent case law and decisions made on gay marriage, right, which is now allowed under the Supreme Court. That should, if you come back to a case like this should go the other way, I would think.
Possibly. The polygamists sued very quickly after the gay marriage decision.
This,
They did not win,
they lost. Okay.
but they were super excited about the gay marriage decision because they thought the same thing.
As, it goes back a little bit to your point that what the amendment seems to be doing is it's a gesture towards the value that we hold or don't hold.
Yeah.
Because we are charting through territory that is difficult, and for the people of the Victorian era, the idea of polygamy was deeply painful and shocking.
Yeah.
And it felt like a violation to them, right? Like they could not understand that this thing they believed to be sacred could be opened up to other people, right? So they, I think incorrectly assumed that this was a immoral choice and that it should be banned, right? So it was a public interest, they believed, in keeping this away. So what the amendment's actually doing is it's putting a stake in the ground that, hey, this is an important thing. Think very, very carefully about this. We cannot create one hard and fast rule. Instead, we have to instantiate it out over and over again throughout these many cases. Maybe killing people for sacrifice is wrong. Maybe polygamy is not. We have to think about it. Like it requires us in each generation, each judge, to think like, oh, have the circumstances changed such that I can see the religious necessity for this and how deeply this person really feels.
Yeah.
I think even like plaintiffs are probably really important if their sincere belief reflected to the court, probably very helpful.
Yeah. And we'll talk a little bit more about that in just a minute.
Going back to the very first one, you were explaining, you said the establishment of religion and the free exercise thereof, you take that free exercise to the establishment of religion. The difference between anarchy, where you have individuals, an individual doesn't really establish a religion, but a group
Correct.
establishes a religion. And I think that's what they're talking about. There's a difference there. How is that worded? What they mean?
Yeah.
You know, because if it's just the free exercise of religion, then you're saying anybody.
And that opens up the anarchy.
Can free exercise their own religion, but if it's the establishment of the religion, then you have a group of people that are executed.
But they don't care though about the establishment, right?
No, they don't.
You're in your heart, you're not violating your innermost moral beliefs, right? Like that's why the amendment is, we don't care about clubs, establishment, right?
Well, all I'm saying is they're arguing that the tyranny part of it.
Or the anarchy.
Or anarchy, I mean, the individuals doing individual things becomes the anarchy.
I'm just so curious about that. If we move that direction in the establishment, I don't care about established things. I care about the morality in my heart, right? And I think that's what it's trying to protect.
Well, that's a position to take, but let's say that it was protecting the establishment of religion for a minute. What that's saying is you gain protection once something's become established enough that a group of people accept it. So it's forcing this thing of, if I was the only person that said, let's do polygamy, and nobody else bought into it, then the court would say, hey, you're going so far outside the norms. But to your point about always evaluating these morals and is this really wrong? Is this really right? Once you have an established group of people doing something, and it's part of their beliefs, it's set forth in writing, this is our doctrine. It's not a situation where they can just say, oh, and this, and this, and this. We just don't like what you're doing, government. It's more a situation of, no, you can see this is how we live. This is what we believe. It's part of it. And there's a whole group that accepts it. And in that situation, should that have a little more protection than just an individual saying, oh, yeah, I'm opposed to taxes and I'm opposed to this and I'm opposed to that? Because that is less dangerous to a country if you force an establishment to exist and you say, okay, you tell me what your established practices are. And that gets a little bit more protection than just the individual on their own.
Yeah, I think pragmatically, that makes sense.
But from the perspective of, it's not very satisfying as an individual to go,
Yeah.
so I have to go join a group to get
Or
protected.
Let a different group dictate my own relationship with the divine. Right?
Correct. Correct. And so there is this fundamental challenge here, but still it goes back to this question of you can't prohibit you have the establishment of religion or the free exercise thereof. I actually think some of these cases, I'm of the opinion that an establishment of religion should have a little bit more protection than just an individual that's out there on their own. I'm not saying an individual should have no protection, but I believe that those in an establishment that are following it should have a little more protection.
Yeah, sure.
Personally. But the courts haven't gone that way.
You know, and the reality of it is in those days, it was certain religious beliefs against other religious beliefs. I mean, they talk about the good of society, but those are religious beliefs. All those people were, quote, Christians who come and, polygamy was not something that Christian does. And even though they say, separation of church and state, we're doing this through the government. You can't separate a person's beliefs from what they do. You can't say, I believe this, but I'm going to do that. Those people all believed that was proper, so they made laws to make those things proper. And so basically it was a certain religion against a different religion in what they were doing.
Yeah.
Did the decision address the whole religions, the established religions beliefs and their doctrine rather than the individual? It focused on the individual, right?
Well, it did talk about how it was part of the establishment as well. But the courts essentially came down and said, if you read the religious freedom cases, they've come down very strongly and said, there's no way for us to determine when an establishment exists. How many is necessary for an establishment to exist? Could one person be an establishment? They go through all these things and they eventually just came down and said, courts are powerless to decide when an establishment really exists, to figure out how many is necessary, to figure out what their doctrine really is. There's actually case law that says the courts aren't allowed to go and have a trial over what a religious doctrine is. They just have to have the church tell them what it is because of the separation of church and state. So the court can't say what a religion's doctrine is. Only the religion can say it. So if it's a dispute in court, there's been a few cases where the church's doctrine was central to resolving a legal issue, and they have to get that from the church.
Even if it's publicly posted online from the organization?
Yes, because what happens is every religion has conflicting written statements. You go to the Bible and you can pull a verse from the Bible and someone else can pull a verse from the Bible and they mean two totally different things. They're publicly posted. We believe it. Which one controls? Only the religion, only the church or the establishment can say how that resolves. Because in religion, there's so much that conflicts. And I don't know of a religion with any, just if you have any amount of text, there's almost always conflict in it. And the religion has to resolve that. If there's going to be cohesiveness, or some say their own people resolve it, But to have a cohesive, established religion, the church has to resolve those conflicts. So, we've talked about these things to some extent, but the question that's left that I don't think the courts have ever articulated well is, what type of conduct should the government be able to restrain? And what should you get exempted from if you have a true religious belief against it?
Well, you have, just as an example, the Amish, have a highly established belief system. So they can stay out of war, right? They don't have to be drafted, am I correct?
So the Amish are really good. They got a statutory exemption from it. Not a
Same as
constitutional one.
vaccinations, correct? They can choose, like as a community, to not suffer.
I don't think that one's correct.
Okay.
So far, the courts, the only precedent, Supreme Court precedent we have allows forced vaccinations. It was from 1906 or something. But the Supreme Court hasn't taken up that case again since then, or that issue.
I'm thinking of like some of the polygamous sects down south, and some of their practices do seem like I think I have a moral problem with some of what they do. And they have sincere belief about a lot of what they do, but like the coerciveness and the like young brides, 12, 13, like I think it's wrong. And I think that the government should have some ability to step in these situations. Because collectively, we all sort of know, hey, like, even though you sincerely believe this, you are doing damage to young children, essentially. And I don't have any justification for that against the First Amendment, but I do really believe it. I do think some of these situations, someone should step in.
Okay, and this is, so one of the fascinating things about polygamy is it did in the 1800s and still continues to shape so much of what we feel is proper in government regulation or not with religion. Because almost every judge that you talk to, if you're in a religious freedom case in court, they will all talk about Warren Jeffs and polygamy and say, you telling me that we can't regulate that? And it's really interesting to me to see, because if you look at, and I'm not, don't get me wrong in this, I am very much for not letting children be involved in relationships with adults. But if you believe in evolution, nature said that 12, 13-year-olds could be parents. The child evolves that quickly, biologically. As a society, we've determined that 18 is the appropriate age. But even that's evolved over time. In the 1800s, it was a lot younger for people to be married. There are pushes, and again, I'm not a fan of these at all, but there are groups out there actively working to lower the age of consent because they say we should be able to, these kids should be able to choose. Who are we to step in and say?
Right, but that's sort of biological fallacy, right? Like I can hit people with my fist pretty hard, like I should do it, and there's lots of good evidence to support that. But if I do it, I'll do damage to them. That may be, long-term damage.
For sure. But just to say though, again, from a perspective of morally speaking, I'm saying it's wrong. But is it really? I believe it's wrong.
Once we start to get into the business of legislating morality, it's a very, very slippery slope.
Is there any legislation not based on morality?
That's a very good question. And that's what I was thinking. When you go back to the very beginning of our talk, the very idea that you can create laws for the furtherance of the general well-being. So any sort of idea that you're going to have as to what well-being is going to be religiously molded. Yeah.
Well, not necessarily, because we have logic, we have our minds. We can say, hey, I can see consequence B came from my action A, and I don't need to ground that out in a religious belief. I need to say that this consequence is bad.
Well, the bad though.
Yeah, and we can ground out that in, hey, how do you feel when you look at this bruise on her cheek? you like that or did you dislike that?
I guess
If
what,
everyone agrees on it, I don't like the way that.
where I'm coming from here and saying religious belief, I would, in the context of how I'm speaking about this, even atheism will be a religious belief.
Yep.
Well, I mean, yeah, I guess you go that far, just whatever ground you have, but wherever you bring it out.
If we're talking about morality,
Value.
yes, it's the values as to what is important, what is good, what is bad, what we should not.
I guess my point is just that we, if we take a few premises, can build more complex logical systems than just, hey, it's up to everybody. Like, I do think if we take general premises and then conclusions that follow from the general accepted premises, we can come up with more complicated systems than just, all right, everybody on there.
And this goes back to pulling us out of anarchy. There's a basis at which, as a country, we've had to agree on some basic premises. And this is where I think Jefferson goes into his social duties and things to say, in this country, we all believe X. And you don't get out of it. Now, it can still be argued that that itself is based on a belief or a religious belief or something like that. But once as a society we've created this, they call it a social contract or this norm that we all operate under, then from there we can extrapolate good or bad to a large extent. But one of the things that's happening in our society, and the definition changes and things, is people are pushing back on even some of the fundamental assertions of what we were built on as a country. One of the fascinating things about this Reynolds case is they said, we're actually built on the family as a fundamental unit of society. And they said polygamy is so foundationally threatening to the family as a fundamental unit of society and what we're built on that we can absolutely outlaw it because it violates this basic premise. Now in society, there's a very strong push to say, let's actually change family as the fundamental basis of society. What that fully does to our society, I don't think any of us have mapped out. The full logical ends of all that yet. There's still a lot of belief associated with it. But one of the points is I believe that all law is based in reality somewhere, whether it's order. If we believe order is an appropriate moral end or peace or any of these things, law is based to achieve some moral end that we believe is appropriate and we pursue. And so I don't believe it's possible for government, for law not to legislate morality. I don't think it's possible at all for those two to be disconnected. But fundamentally, can we build on a basis that our society agrees is the norm? But all of these things are being challenged today. And one of the things that, if you look at the gay marriage decision, and whether you agree or disagree with it doesn't matter for purposes of this conversation, the gay marriage decision actually left an established framework of American jurisprudence and switched to a whole different framework in its decision. Because one of the things that the courts had consistently held before the gay marriage decision was that they weren't going to base decisions off of a person's inward feelings. There had to be something tangible, external to them. And in the gay marriage decision, they said that the law made the gay couples feel less respected. And because they felt less respected, they were being discriminated against. And when the law starts to delve into now this realm of personal belief and personal feeling, we suddenly have people saying, well, I'm a boy, I'm a girl, I'm anything in between. And I'm not here to mock that. Or to, again, say anything good or bad about that. It's just to say now, we're in a state where everything's in flux. Because the law has opened up this door to say, we want to go internal. And the Supreme Court in this case, in these religious cases, are going, whoa, 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 we can't go internal. That leads to anarchy. And our court now is saying, we're going to go off the way people feel, which is a very different basis and approach than had existed in America this whole time. All the precedent refused to go there based on how someone felt. And they moved to that. And there's still battles over how much that gets expanded, how much it doesn't. That's still playing itself out. But more and more, you get things where someone says, whoa, I've got PTSD from this, and so give me $5 million. And the amount of damages are skyrocketing in these cases based on the way someone feels inside. There's no physical harm, no bruise. And I'm not, again, mocking the fact that there's true emotional harm. But for forever, the law refused to touch it. Then we can't go there. Because it opens Pandora's box. And we're now going there. And it will be interesting to see how that shakes out with these things. But it brings us back to this question of, well, what's the conduct the government should be able to restrain? And I think, at least I would guess that you would say, well, if it's conduct that falls on the left side of the scale, the accepted social norms we all have to agree to, the government can restrain those. Stuff on this side of the scale that's supposed to be left to the people, we would potentially have more religious freedom protection for. But I'm curious if anyone has any other thoughts on that.
That laws in pursuit of social order, say the pursuance of a particular social order, ends up necessarily having greater faith in the government than it does in people. So if you're not making laws which are in pursuance of personal liberty, if you're not actually valuing the development of a person's individuality, and that development will actually end up producing a better society, then we could swing to the left or we could swing to the right.
Except, I think that some of the founding fathers would push back and say, that's right, to an extent that we are pushing back on the individual liberty to the extent necessary to pull us out of anarchy. Because they said we've seen from the human condition that humans left to their own devices with no law will go to the state of anarchy. And so law, to create a state of liberty, we have to pull ourselves out of anarchy. So there has to be a law that checks some human nature.
So the first step from there would be that if when one person's personal or individual liberty ends up coming across another one. So the most obvious example of that is that when you go and physically harm another person, and then you would be building from there. And it's not to say like, oh, you have some ideal and we're just going to stick with this. You have to deal with the realities of life.
Yeah, but we often say that phrase of, well, my rights end where they start to interfere with your rights. I actually highly disagree with that statement personally. Because, for example, if I get charged with a crime or I'm in court, I can demand a jury trial and I just infringe on someone else's rights. They have to come in and be on the jury. So that's a necessary check and balance in our society, a very healthy, appropriate one. And I believe there's all kinds of situations where to create this state that pulls us out of anarchy, we curtail individual rights. But
in building systems.
But that is supposed to be the federal, I believe the founders were saying that's supposed to be as limited as possible. Only curtail the individual rights to the extent necessary to pull us out of anarchy, and then let the personal rights, the other things take over, moral side of things. But we still will curtail individual rights. for the benefit of a collective. We believe, founders believe, we believe that a society gives us a better state to exist in than no society. And so we do put checks and balances even on the people. And if the system of checks and balances isn't just a check on the government, law is a check on the people and their actions.
So
And it has to be in order to create this fully functioning thing. We check the government checks us. It's a circular process.
So I guess the thought there goes to, if, when we're trying to check the government, if we're talking about limiting government, is the field entirely open as to the kinds of actions that the government can be engaged in? Because that's essentially what, when we're talking about the church, separation of church and state, we're keying into the idea that there are certain types of activities which are the sphere of government. And then there are certain types of activities which
That are
are
not.
not the sphere of government.
Yep.
So it would be in really delimiting, like, what is the limits of,
The government.
yeah.
Yep. And the Constitution was set up with the under that premise that this is the only power you have, federal government. But then they use these big, ambiguous words like, general welfare. And you go, I don't know if they just overlooked that or if they just had a solid definition of that they all knew what that meant. I don't know entirely how that should count. Matt, did you have something?
Well, just even to that, again, it's like, but maybe they weren't trying to define everything, because that was kind of, we're trying to find this balance, and that seems like on the mission, you have a white handbook that gives you this set of rules, and then every mission president comes in and adds more rules because missionaries do more things. And then the new mission president is told to throw those out because the set of rules was supposed to be sufficient. And then that mission president makes all these new rules, and it's just kind of a cycle. And so maybe they did intend to not, be direct, but I was just going to say, we were talking about like the structures. I just think of like traffic is like a good example of like, don't really care what you think, but we're going to build a society that can function harmoniously. And so everyone's going to drive on the left. There's going to be a speed limit. And then, maybe there's some leeway and discretion and discussion on what that speed limit should be. But even that one is interesting, and maybe it's a different conversation, but it's like, at this point, we probably have the technology to say you can't get in a car if you're intoxicated, but that's still freedom that's allowed.
Until 2026.
Or are they going to be in all cars then?
Yeah, they're requiring all car manufacturers to put that in.
Would you go to reboot it before it goes?
No, they actually have devices that watch your eyes.
Oh.
And so it's a facial thing, and it watches you. And if you're falling asleep, if you're intoxicated, it will catch it and just pull over and stop.
Do the car manufacturers have access to all that data like on your face at all times?
I would assume so, but I don't know.
Not sure how they like that.
Yeah, sure.
But by federal mandate, those are going to be in cars. I'm pretty sure it's starting in 2026. All cars have to build with them.
Actually, all the ladies, yeah. Yeah, I was thinking that.
Your car just keeps pulling over. This is not ADA friendly. Okay. But yes, but it is. But then, and that is one of the questions, even from the beginning, going back to Isaac Asimov. Once we have the technology to prevent something, what then do we do with it?
Yes, and that's a quandary I have, we have all this stuff, we have smartphones, we have this, we have that. We have all these cars now that will brake automatically, that will orient a car beside you. And so we get in the car thinking the car is going to protect me, I don't have to think for myself anymore. And so there are problems with technology that we have to figure out how we don't let the human rely on it instead of thinking for themselves. You have a person with a staring at their smartphone, they see the green walk light says green, so they just start walking. They don't bother to look to see if somebody's running the red light or not.
Yeah.
Because we're being protected by technology, and it doesn't protect us from human deficiencies.
And when I was a kid, I knew tons of phone numbers. Now I know two. mine and Phelan's. That's it. I don't even know my mom's phone number anymore.
Can't believe you're doing
It's in my contacts.
Yes, it's saved in my phone.
There's mathematics that's illegal. So if you figure out a prime number greater than a certain size, and if you do not report it to the government, you're committing a crime.
The government wants to know all the new prime numbers.
It's a prime number crime. So if you.
Yeah, for the
If you find like a prime number that nobody else knows about, and if you don't report it to the government, especially in the US, you'll be falling apart of national security laws. Prime numbers are used in encryption.
It's the security.
Encryption goes into all sorts of data.
If you know prime numbers that they don't, it means that you can hide things from the government that are dangerous.
Yeah. So,
Well, wait a minute.
yes.
There's a thing.
Numbers on my phone as we speak.
I'm talking about prime
numbers. Big prime numbers.
No,
We're not talking about Amazon.
Amazon. I don't know Amazon.
No, you do not have one of these prime numbers on your phone. They're very large numbers.
Those numbers are like, 500 digits, 1,000 digits.
Yeah, they're big numbers. Gopi is our physicist in residence, so turn down for these types of things. So going on just real quick, since we're getting close to the end here. This leads us up to 1990. So the court, and to be clear, the court has had they kind of have this back and forth of, yep, we'll protect this right, but we won't protect this one. They've been vacillating back and forth what they're going to do. But in general, they want the government to show kind of a compelling interest in why they're regulating the conduct and why they're taking away someone's religious liberty. So if you look at these are cactuses. They're just a small cactus, and it's called, I don't know if it's peyote or peyote.
Peyote.
It's like coyote, but it's a drug that's classified as illegal in America. It's one you can just get from the cactus. And so this Native American Indian tribe, they have a sacrament where they ingest peyote, and it's part of their religious rites. These two Native American guys get fired from their job because they failed a drug test because they were at church or whatnot. They didn't fight the firing for cause, but Oregon denied them workers' compensation because they said you were fired. We don't have to pay unemployment insurance. They denied the unemployment insurance because you don't have to pay unemployment insurance if you're fired for cause. It's only if you're laid off. And so they said, hey, you actually have to give that to us because the state is saying our religion's not a value. If we were fired for following our religion, that's not a for cause thing. They based their decision or their argument on a case called Sherbert v. Werner, where in Sherbert, there was a Seventh-day Adventist who was fired because she refused to work on Saturday. And the Supreme Court there said, yeah, you got to give her unemployment. You can't not, because that's not a for cause termination. And the Sherbert case was back in 1963, I think. And Employment Division versus Smith is now 1990. Oregon Supreme Court says, yeah, Oregon, you got to give them unemployment compensation. That's what the First Amendment requires. Oregon unemployment didn't like that. They appealed to the Supreme Court. In this case, these poor guys, they were at the Supreme Court twice. The Supreme Court took this case up twice. They were in litigation forever. But ultimately, the Supreme Court came out and just said, whoa, we're getting sick of all this. This is Justice Scalia. He's a Catholic. He's a staunch, supposedly religious guy. And he says, as long as the law is neutral and generally applicable, he says, you can't come complain to me about any burden on your religion. No religious freedom challenge for you. Because he's going too much like anarchy. If the government has to pick and choose and exempt and who's not and who's in and all that, it says way too much of a burden. Neutral, generally applicable. don't come crying to us. And because the law just said peyote is illegal for any purpose, it didn't target religion, it was neutral, it applied to everybody. And so they said no unemployment compensation for you. So in light of this, so this is crossing all three levels of the scenarios that we looked at. The Supreme Court case in Braunfeld, the Pennsylvania case, was talking about level 2. And the Reynolds case with Pulliam was talking about level 3. But the court just said, no, if it's applicable to everyone, don't come talk about religion to us. Congress was actually so appalled by this because it really gutted almost the whole meaning of the First Amendment, other than to say what was left is they couldn't say a religiously violent, a religious thing, had to be neutral. So they couldn't say Jews can't do this or Christians can't do that. And other than that, there was very little protection. And so Congress passed what they call the Religious Freedom Restoration Act that restored some level of oversight that said the government has to have some level of justification to explain the moral basis for the law that justifies overriding their religious practice or belief. Most of our challenges today rely on the Religious Freedom Restoration Act. They rely on a statute, not the First Amendment. So we hear about these religious freedom victories. Almost all of them are based on a statute, as opposed to the First Amendment. The Religious Freedom Restoration Act has been up for repeal a couple times in Congress. Our own Congressman Ben McAdams sponsored the Equality Act, which repealed, if it had passed, it was stated in there that it repealed the Religious Freedom Restoration Act. And when asked about it, he said, oh, don't worry, you have the First Amendment. It doesn't change that. And so religion is at this very interesting crossroads right now, where we have what they call it RFRA, the Religious Freedom Restoration Act. And Hobby Lobby case, a bunch of these cases relied on Religious Freedom Restoration Act as opposed to the First Amendment. So that brings us, just to give you guys some fun or uplifting content, On Fire Christian Center. This is COVID years. So this is, I guess I don't remember if this is 2020 or 2021. So I actually think this was 2021 though, because there was a resurgence. And even here in Utah, the area authority of the church asked us not to go to church on Easter. If I remember right, 2021. So they said on Holy Thursday, an American mayor criminalized the communal celebration of Easter. So the mayor actually said, no church services this week. That was the order because of COVID. The judge says that sentence is one that this court never expected to see outside the pages of a dystopian novel or perhaps the pages of The Onion. But 2 days ago, citing the need for social distancing during the current pandemic, Louisville Mayor Greg Fisher ordered Christians not to attend Sunday services, even if they remained in their cars to worship. So this On Fire Christian Center says, we'll park cars 6 feet apart, everyone will stay in their cars, and we'll have a worship service with a big microphone outside in the parking lot. And Kentucky said, or the mayor said, no way. He said, so they can't do this. And he says, the mayor's decision is stunning, and it is beyond all reason unconstitutional. He particularly went through and said this was targeted at religion, said it didn't apply equally because the liquor stores were still open. So there you go. In the situation where you leave the liquor stores open, but you say religion can't meet, they said, no, that doesn't fly. That's not generally applicable. It's not neutral. So that was a First Amendment challenge that prevailed. If the government said everything's closed on Sunday, including churches, Pennsylvania case, it may have been a different story. But because they left alcohol open, because who's going to be the mayor that shuts down the alcohol stores? Not that guy. So these are some of the questions that come up. These are all things that have come up to the courts. I said cocaine, but drugs. You know, if you have a religious belief that you should use a drug, should schools have to allow a student that worships on Wednesdays have that school day off? Should the Amish not have to pay Social Security because it violates their religious principles? That's a real case. Should those with religious beliefs against killing be exempted from the draft constitutionally? There are some that have gotten it statutorily, where they convince Congress to say, yeah, there's so few of you, we'll let you out of it. But from the constitutional perspective, should a parent be able to refuse medical care for a child, such as life-saving blood transfusion, if the care violates the parent's religious beliefs? Jehovah's Witnesses don't believe in blood transfusions. Should the law be able to ban all alcohol, even if it is used for sacramental purposes? They had a lot of fun with this during Prohibition. Does the Postal Service have to give postal employees their Sabbath day off? You guys know how that case resolved? That's a recent case. Went to the Supreme Court. The Supreme Court said you have to give them their Sabbath day off. Interestingly. But that was under a statute. Wasn't the First Amendment.
Does that mean they had to give them 1 day out of 7? They would work 6, or
And you can make them work any day, but they can't compel you to work on your Sabbath. Because a postal worker in, I think it was Pennsylvania, got laid off because he wouldn't work Sundays. There was only 4 of them in a rural area, and they said, you got to take your turn. And he sued. The Supreme Court said, no, you can't make him work on his Sabbath.
How does the Supreme Court justify that and not have that be the case across all federal employees?
Well, it is now.
But it's not just,
No,
not just those out there, everybody.
it is now the case for all federal employees.
Okay. Interesting.
so it has to be for federal employees though, or
Well, this statute actually applies to businesses. So businesses have this new burden. It's a brand new thing where they may have to give people their Sabbath off. There's still a test. The Supreme Court has a balancing test, they say, with it. So it's not just absolutely have to, but the business has to be able to show that it's impossible, basically, to accommodate that.
Especially if you start to drift into infringing on other people's rights a little bit.
Absolutely.
They have to, they need people on Friday and they just can't get.
Yeah. So you get called in because it's not your religion. Every Friday, every Sunday. But it's interesting how they've gone and looked at some of these. So most of these they ruled, nope, you don't get drugs if it's part of your religion. Nope, you don't get a certain day off of school. Nope. Or yes, the Amish have to pay Social Security. We're not going to exempt you from the draft. Anyone can be taken unless the statute says so. No, parents can't refuse medical care for a child. And yeah, we can ban alcohol, other things. So far as how those things have kind of gone in American history. So we talked about a lot of these, but again, I would really encourage you to think about what it protects. What are we protecting here? And if the law can criminalize any conduct, then what does the freedom of religion protect? Because if they can say, hey, it's a crime to meet together and learn about the Constitution, at some level, there has to be some pushback. In these cases, obviously, that we talked about, we're falling on the side of, yes, we can. There are cases that say, no, you can't do that. But there's still not this clear principle that's ever come out about where that balance is, what justifies that. To me, one of the biggest things that I understand about constitutional cases and religious things are the things that we live, the things that we care about, that we talk about, greatly impact how these cases resolve. The courts are so looking to societal norms. They're looking to understand what people are saying. If there's a pretty strong disagreement in society, they have deep respect for that. when something goes silent and it's not talked about anymore, it's not considered important. And silence is, you can almost guarantee that if you go silent on something, you'll lose that constitutional challenge at some point. We have to talk about the things that matter to us, because ultimately the Constitution and this and the courts and this balance of what works and what doesn't, they are looking to what functions in a society today. One of my favorite issues that clients bring up to me, I'll get contacted occasionally by clients that go, hey, did you know that the income tax is unconstitutional? And they say, here's all the cases that show it. Will you help me file this brief? And I say to them, I say, no matter how many cases you have on your side, no matter how much precedent you have, you will lose that case in court, because what judge is going to rule from just a practical perspective that the income tax is unconstitutional? I said, it's so vested in American culture now. There's no way a judge will overrule that. There's a whole practical side to the Constitution. And things become practical or entrenched in society when we stop talking about them, when we stop arguing about it. The income tax, we stopped arguing about as a society a long time ago. We just accepted it and moved on. And it's now greatly entrenched, regardless of the legal merits of any argument for or against. So I don't know if any of you have any final thoughts, comments, things you want to throw out, questions. But again, I'd encourage you to think deeply about the things that matter to you and talk about them. Keep that thing alive, keep it as part of society, because we have to in order to maintain our rights. And John Adams said, the Constitution only governs immoral people. Because he knew that there was this balance. They weren't defining everything. They weren't putting everything in place. And there was going to be this back and forth checks and balance thing. But if the sister's calling.
This is really how she behaves.
If the government, if the people become so immoral, the government will become immoral. The two go hand in hand, and the system destructs. And we can obviously get discouraged and look around and say, oh, society's so immoral, I can't do anything. But there's actually a lot of things. Society will still correct itself. We've seen society address immoral things and change when people speak out, when they do things. Kind of like you talked about with the guy going to jail because he opposed the Fugitive Slave Act. We can influence actually the direction of society. It happens all the time. And we just have to be willing to do that. So I appreciate you guys coming today. If you have things you would like to talk about next time, let me know, or any of these times. Otherwise, we'll keep going on. The establishment of religion side is a very interesting side of things too. We get into all kinds of fun issues there. And so we'll probably do that next time unless other people have things I want to talk about. The next meeting, it's the second Thursday in February. Forget what day that is. But we'll meet here again. And then we also have, we're going to do Believe Professional Network meetings. Also, those will be, there's one on Tuesday here at noon. We serve lunch at those. We'll be talking about the Corporate Transparency Act, potential constitutional challenge to it, and some of the things we can do to improve the culture of politics in America. So Phelan's saying it's February 8th. The next meeting here for the constitutional one. And then finally, if you fill up for it and have it, I am running for Attorney General, gathering signatures. So if you haven't signed, you can do that. If you have, thank you. And you don't have to sign just because you can. But thanks everyone for coming. And then there's, if you want a shirt, Believe shirt or wristband, you can get those too. Thank you.